don't scream or I'm gonna kill you. So I calmed down, tried to keep my voice down. Then you feel like see my girls, I just didn't. And I was asking what was wrong, telling me to go through my phone. I just wanted to know like what was going on. Cause I didn't know. It just happened.
And you said you felt a cut. Where did you feel cuts on your body?
It was just more like all this was like stinging.
And where are you talking about? Sorry, for all this. The neck.
My face was drooping. So I thought when he was punching, that my tooth had went through my lip. That's what I thought. But from what I seen on the pictures and the medical records, it clearly was like.
And then you said after that, he was then sitting on top of you. Did he still have the knife in his hand?
Also ready, there is no offer for the record.
That's correct, Your Honor. As a one housekeeping matter, it's our expectation that based on the testimony, there is a likelihood that additional charges may be added as well.
And do you know about that?
No, I've not heard of any additional charges until this point in time.
I mentioned to you earlier.
You said have.
It's the people's intention that after testimony today, likely will be able to add an assault with intent to murder along with an unlawful imprisonment.
Okay. Does that change your perspective on what your client wants to do? Or?
My understanding was the people are demanding exam, right?
Or the victim is present.
So there's no opportunity to do anything for the defense.
No, I understand that. I'm just saying they've stated their intent to add 2 additional rather significant charges. Did you need an opportunity to discuss that with your client or not? I mean, I'm not saying you have to. I just want to make sure you have opportunity if necessary.
Your Honor, I don't need the opportunity given that we have no option to do anything other than hold the exam or demanding to hold, so it's being held.
Okay, and your client understands that additional charges can be added. That I want to make sure that he's understanding what the people are indicating.
I'm not sure about that. Either I could explain it or the court could explain it.
Well, I don't know that that's my job. Pardon?
If we need to pass it briefly, I have no objections. You can talk.
Yeah, I mean, I don't know if I want to make sure that he understands what can potentially happen.
So basically, they're going to add an assault with intent to murder charge, which is their right. They're giving us notice, and they're going to try to prove that they believe. They have the right to amend the information at any time.
Sir, did you want an opportunity to speak to your attorney about that? No, you're good. Yes, sir. All right.
People first of all, Sherelle Knight, Your Honor.
All right.
Okay, so your first and last name, record please.
Right.
How do I spell your first name? Thank you. You may inquire.
Thank you, Your Honor. Good afternoon. Do you know a James Atkins? How do you know him? And if you saw James, would you recognize him today? And is he in the courtroom? Can you briefly identify something he's wearing and where he's sitting? Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Record shall so reflect without objection.
So I'm going to direct your attention now to July 3rd of 2026, okay? On that date, were you at 2910 Cascade Drive? And is then Ann Arbor, Washtenaw County, state of Michigan? And on that date and at that location, did the defendant do anything to you that made you come into contact with the police? So I'm kind of going to start. So what happened that day involving Mr. Adkins?
It's amazing. Yeah, just got back from dumpster diving. He found out this massaging. Try to see if it worked. Start my back with it for a second. I was doing my makeup and next thing I know, it was punching. It felt like it was just punches at first, but once he threw the knife,
So I'm gonna take you back. So you said you were sitting there. Where were you at in the house? Is this a house or apartment? Okay.
it's on the bed sitting on the floor. I like to be drunk, one sitting Indian style. And so my parents too.
Okay. So you were in the bedroom, you were on the floor, and he was on the bed.
Well, the living room was great, but
Okay. And you said out of nowhere he attacked you. What did he do first? What happened first?
it was from the back, so to me, it just felt like he rushed me, like from the back, and just punching me. But like I said, I seen him throw the knife. Obviously, felt like the jerky, but I didn't know that that's what it was.
Okay, let me just stop you there. You said twice that he threw the knife. Explain that to me.
Okay, so after he was done punching, I'm guessing maybe it was the knife that he had, but he threw it down. That was in my view.
Got it. Okay. Okay. Go ahead, Miss Sutton.
So when you said he punched you, how is he punching? With a closed fist?
I believe so.
Okay.
Or with the butt of the knife.
And where was he hitting you on your body? Just your face? Okay. And how did you feel during that moment?
He was scared and confused. Really confused.
And was he saying anything when he was hitting you?
Not while he was hitting, because after he threw the knife, he just sat on his legs. That's when he started saying, "Who's on the way? Are you setting me up? Shut up, bitch. Don't scream, or I'm gonna kill you." So I calmed down, tried to keep my voice down, just begging to let me see my girls. I just didn't. And I was asking what was wrong. Telling me to go through my phone. I just wanted to know why, what was going on. Because I didn't know. It just happened.
And you said you felt a cut. Where did you feel cuts on your body?
Much I thought. It was just more like all this was like stinging.
And where are you talking about? Sorry for all this. The neck.
My face was drooping. So I thought when he was punching, that my tooth had went through my lip. That's what I thought. But from what I seen on the pictures and the medical records, it clearly was like.
And then you said after that, he was then sitting on top of you. Did he still have the knife in his hand?
It was like after he was done punching me, he threw the knife and then said,
Okay.
that's what I remember.
Okay.
When he was telling me to not scream, I don't know if he had another knife in his hand or not, but I didn't see it when it might be anymore because I was just looking into his eyes and just trying to figure out what was going through his head and what I could say to get him to get off. He knew I wanted to get up.
And before he threw the knife at any other point, did you feel the knife touch anywhere else on your body?
I wouldn't say touch, but I felt like, I don't know if it was his hand or something, but in order to, he would keep holding me down, and I felt like something was in my wrist. I don't say like I wouldn't say like it was like a stab, but
Felt something.
it just
And when you felt something in your rib, did he say anything to you during?
that's time. Don't scream.
And then you said he was on top of your legs. Were you laying on the ground at that point?
I'm still sitting on my back.
Was he facing you when he sat on your legs?
And then what happened as he was sitting on your legs? What happened next?
He, no, I asked him if I was gonna be okay because I was bleeding so bad, and he handed, I guess it was a pillow, he handed something to me to stop the bleeding. And told me that I'd be fine, just to hold it on there. And, then I went to, let's go lay down on the bed so we can both calm down. And so I did, I went to lay down, I tried, like, I was trying to lay down comfortably, but just freaked out and, yeah, we just laid there for a second and then eventually he ended up calling them.
And what were you thinking at that point when he called 911?
The person that I loved because he cared and he knew that I was hurt. That it was just confused.
And during this assault, at any point, was there anyone else in the house with you or the apartment? And during the assault, were you trying to get up to escape at any point or leave?
I mean, I wouldn't say that I was trying because obviously big he is, but I was really trying to find out what was going on. Why he was attacking me and why he was upset. And I think that's really what I wanted to know. I didn't really try to just run out. I was just in shock.
And did you have any injuries from this assault? What injuries did you have?
I guess he almost hit my jugular. That, and then my lip was, I just seen the picture, but my lip was wide open. I had, my whole face was black, except both of my eyes. My lip was humongous. I had like 13. You and they're still in actually, haven't actually solved yet. And mentally, uh,
And on the date of the assault, the same day, did you have photos taken of those injuries?
I keep pretty sure once I got there, I was freaking out and they thought they gave me us. I was in and out of pocket.
And sorry. Your Honor, may I approach the People's Proposed Exhibits 1 through 5?
Yes.
So sure, what did I just hand you? And if you need a break, we can take a break.
Pictures of right at that walk was outside and I had to go back and get a sweater or something.
And when you say echo, you're referring to Mr. Adkins? And are those photos, if you want to look through all of them before answering? And if you need a moment after too, we can take a break. Do you want to take a break?
Okay, you need a minute?
Oh.
If you need a minute, you just gotta let me know, okay? I know, but gotta make sure you can make it through it, okay? Good.
And are those photos fair and accurate representations of the injuries you had that day from the assault? Your Honor, I would move to People's Proposed Exhibits 1 through 5.
Any objection or voir dire?
Honor. Thank you.
Exhibits 1 through 5 are admitted.
Thank you, Your Honor. May we publish those to the court?
Yes.
Cheryl, if you want to.
Yes. Thank you.
If I may have one moment, Your Honor.
Miss Knight, my name is Ben Dunawith. I am the public defender for Mr. Adkins. I'm not going to try to trick you or anything today. If you don't understand the questions or you want them rephrased or just repeated, feel free to ask. Okay. Did you get to Mr. Adkins' location the day before? That would be July 2nd. About what time did you show up?
Like that, after close to eat. I was going over there because it was my mom's death thing. I wanted to quit that for it.
Okay, was it like, well, it was before midnight because it was July 2nd, right? But was it dark out?
Necessarily argue. But they just about to be.
Okay, so like say 8 or 9 p.m., something like that. And did the two of you start drinking right away? When did you start drinking?
Object to relevance. This assault occurred on July 3rd. I don't know how this is relevant to the assault that occurred the next day.
I think if you drink enough and consume other things that may impair your memory, it's highly relevant. I mean, that her memory of the incident is the whole thing.
And there was no previous testimony to any substances or things being involved on. In this.
I'm going to sustain the objection. You'll have to figure out a way to tie that up, counsel, and lay foundation for the asking of those questions.
Okay. Well, this assault you've described to the prosecutor happened the next morning, July 3rd, right? Approximately what time of day was that?
Well, for 7:09 p.m.
Did the police show up pretty quick after this happened? Okay. Was 911 called like immediately when it happened?
About 20 minutes. I don't know, it felt like 20 minutes after.
20 minutes?
No.
Okay, but you're not sure.
Sure. Because I wasn't looking for it. It's ready. Like,
So if the police showed up around 7:09 a.m., you think this would have happened at like 6:50 a.m. approximately? Okay. What time did you go to bed the night before?
sir,
Okay, no, it's okay. It's all right. You're good. Go ahead. Go ahead, counsel.
What time did you go to bed the night before? You
I didn't sleep. We didn't sleep. I didn't sleep because it was my mom's death date. I was trying to process that, deal with the emotions of it. So,
okay? And did Mr. Atkins sleep?
um,
Okay. Did Mr. Atkins consume anything that would have made him not sleep?
very,
Did you tell the police that he at some point consumed methamphetamine?
sure, yeah.
Okay.
Didn't go-
Did you also tell a police officer that Mr. Atkins had got you addicted to methamphetamine? You never said that to sorry, just a second. Well, do you remember talking to a pretty big officer at the hospital around 11:45 a.m. that day? Like taller than me? Okay. Did you tell that officer Well, do you know him as Officer Doder, or do you remember his name? Doder. And you remember talking to him? Okay. Did you tell him that Mr. Atkins got you hooked on methamphetamine?
Oh,
Okay. But you're saying neither you or Mr. Atkins used any methamphetamine during any time relevant to this case? Okay. Did you or Mr. Atkins use any methamphetamine on the second or the third? Did you? When? Both? How were you using it? Okay. Was Mr. Atkins using it in the same way? How was Mr. Atkins using meth? Okay. What's the difference between the needle and smoking? Can you describe it for us?
as far as his reaction, I can't describe what it didn't have, but I definitely, it's cleaner, it's quicker, doesn't take as much.
Okay.
If I can say,
Does does methamphetamine affect your memory at all?
yeah, but didn't agree as far as that. Traumatic experience and just trauma, affection.
Okay. Did you consume any other intoxicating substances during that time period? The second to the third, when you were at Mr. Atkins.
I didn't eat, my bottle was still laying there when I went back after I got out of the hospital, so I didn't even drink my whole half a pint of liquor. So,
So you drank less than half a pint of liquor? Um, and you said weed? Anything else? Okay. Did the combination of those three substances affect your ability to recall events at all?
Your Honor, the object has to ask and answer. She said it did not affect her memory. It's just instead.
I'll allow the answer. Go ahead.
Okay. Um, did you sleep the night before? Like the first to the second? Okay, like full night's sleep. Okay. And what time did you get up on the second?
like 6:30.
Oh,
So, actually, I work by 6.
so would I be correct doing the math in my head? By the time the police come to Mr. Atkins' house, you had been awake for more than 25 hours? You said 5:30?
Yeah, I guess I went to maybe like 12. Yeah, I guess you something, but
Okay. Did that lack of sleep have any effect on you that you could discern? Um, and then you had testified you're sort of when the assault was about to happen, you're both sitting on the bed. Is that right? No? Okay. And your back is to him, right? And he essentially starts assaulting you, but you can't see. Um, and you were cut on the lip, is that correct? Um, how deep was that cut?
bleeding. So,
Okay, and you got a bunch of stitches for that? Did you leave the hospital the same day or the next day or several days? That would be the 4th. Okay. And what about the injury to your neck?
Um,
Okay. And do you know how blood would come out of an artery versus a vein?
Jack, she's not a medical professional.
If she knows the answer, she can still answer.
I'm gonna sustain the objection.
Okay. Was blood spurting out of your neck?
I can't tell you if it was because I was so focused on my
Okay. So was the lip the worst injury of the two?
this. To me, what, but got in the ambulance and wanted to lay back. This is what hurt most. I couldn't lay my neck flat because this is what hurt most. But the blood from my mouth, I saw it.
Okay. And then you told the prosecutor after you're caught, Mr. Adkins is basically trying to assist you with the wounds. Is that right?
But on my mouth, the tried to stop the bleeding. You want to call that?
Okay. So he's showing some concern for you at that point.
So
Okay. Do you recall him calling 911? Do you recall what what he said to them? And you were like in the same room at that time, right? Okay. And do you recall you actually talked to 911? Do you recall what you told them? What did you tell 911?
exactly what you told them, I agree with everything you said. So then, yeah,
Okay. And is it fair to say what he told them and then what you also told them is different than the story you're telling in court today?
I mean, as far as the why 911 was called,
No, no. So let me just rephrase it. Maybe it'll be easier. But Mr. Atkins called 911 and told him there's two suspects and gave a description. Is that fair? Okay. And you then told 911 that you agreed.
yes.
Okay. And today in court, you're telling us that is not true. Okay. So, and you're telling us that the reason you agreed with him is so that you would get medical attention. Okay. And then the police showed up pretty quick after the 911 call, right? And you first, I don't know if you would know the officers, but you talked to somebody named Officer Sparling or an officer from Ann Arbor.
That a yes?
Yes.
Okay. All right.
Good.
Yeah, you're good. You're good.
And you remember your contact with this person, right? All right. Did you initially state to Officer Sparling, they came up from behind me?
Yes.
And why did you say that?
You're still saying that's it. And I was going on what I needed to because he was right there and I still was here in my life. Well, so there I still was here.
Where was Mr. Atkins when you said that?
Guys coming up behind you, standing right here.
The officer was standing right there too? Like, okay, like three-way conversation? Okay. You just, so you said you feared for your life. Did you think Mr. Adkins was gonna kill you?
Yes and no. Yes, because it wasn't him when he was on top of me and I was looking at his eyes. It was not him. He saw me and telling me to shut up and kill you and tell me the truth. At that moment, because it was a different tone that was coming out of him, yeah, that moment I felt like he could kill me. And obviously it was bleeding really bad, so I didn't know at that moment that the knife caught my face like that, but yeah, there was a chance. I mean, there were butcher knives everywhere. I knew that. I lived there with him before and, just when I moved out,
Okay, so, would you say he's like physically stronger than you too? Or,
I mean, I not at that moment because whenever I moved out and he wasn't eating like when I was there, I fed him all the time. And he was a lot more when I and when I moved out. So no, not at that moment.
okay, did you think he intended to kill you at that time?
I will do that. But the injuries where they are. I don't know what else now. Um uh,
Okay. When you said there was knives everywhere, as like scattered around the apartment, like not for cooking, just so if he wanted to grab a knife and use it, he could at any time. And for the record, you're shaking your head yes. You at any point ask if Mr. Adkins would go to the hospital with you? The officer asked Mr. Adkins if Mr. Adkins would go to the hospital with you. Was that before the officer determined he was a suspect? Okay, so like, right,
the door and I grabbed my and the officer was like, come on, let's go to the ambulance is about to go. Me and the officer were just a little bit. And so we're back. He goes, wait for her. Oh, that's what, yeah, I gotta go grab a sweater. And when he went back in, that's when the officer looked at me and said, did he do this to you? He did. He got out to the officer and he back in.
You say he went, the officer did. Okay, right.
no further questions.
Any redirect? Yes. All right. Ma'am, thank you very much. You may stand.
Your Honor, this witness is dismissed.
Any objection?
No.
All right, this witness is excused.
Thank you. People would next call the detective when here.
Please come forward and be sworn.
You solemnly swear from the testimony about to give the jury. Thanks, Coach. First of all, where?
Detective Justin Quinn, first name is JESSICA. Last name is Quinn, Q-I-N.
All right, make question.
Thank you, Your Honor. Detective Quinn, what do you do for a living? And how long have you been employed there?
11.
Do you have any prior law enforcement experience from that?
Yes. Sarah in Park for 11 years prior to that, I was for us.
So I'm going to direct your attention now to July 3rd of 2026. Were you working on that date?
I was an on-call detective and they called me home.
On that date?
Yes.
Okay. And what did they call you in reference to?
It's just sad.
And due to that call in, were you dispatched over to 2910 Cascade Drive?
Yes, I came to the station and they asked me to make a search warrant because I needed to.
And did you do that? And did you execute that search warrant at that residence? And is that in Ann Arbor, County of Washtenaw, State of Michigan? Okay. And what did you observe in the residence when you arrived there?
It was a very dirty apartment. There was bugs flying everywhere. There was knives. Notifications. There was specifically one knife that fell right on the windowsill. This kind of a makeshift windowsill next to the window. There was a mattress on the floor, also a lid.
And when you mentioned the windowsill where the knife with the blood was, where was that in the house? Is that in the living room?
Yes, to the right of the front door, sitting right on there, there was a like non-serrated knife that looks like a steak knife, and it had blood on it.
And did you take photographs of that scene?
Sure did.
And were you there with Detective Detroit as she was taking the photographs? Without them being taken?
Yeah.
And you may approach the witness with people's proposed exhibits 6 through 11.
Yes, you may.
That's my favorite color. Yeah, that's.
That's good. Okay, one moment, you're to remember these. Hey, detective, what did I just hand you?
Sure, the living room.
And that's the living room at the 2910 Cascade Drive.
Yes.
And we'll go through each one individually. What is the next one?
The next one is shows like a closer up look of the bed. There's a bloody pillow on the bed.
And number 8, I believe.
Number 8 is there's blood all over, like some kind of pad that they had. One of those pads that you could see in a kid's playroom. It has blood all over it. And then there's also, and that's right next to the bed with the bloody pillow over it.
And 9.
9 is a picture of the non-serrated steak knife that we found. As you can see, it's kind of like I don't know if it was like kind of a table that flies onto the window, so it kind of looks like a window. But it was right next.
And is that the knife you were referring to? And 10.
There's also another picture after we picked it up. And
It being the knife.
then also number 11. And as you can see on this picture, there's blood along the whole entire skin.
And are those fair and accurate representations of the scene that you observed at 2910 Cascade Drive on the day that you executed that search warrant? And Your Honor, the people would move to admit people's proposed exhibits 6 through 11.
Any objection or voir dire?
No.
Exhibit 6 through 11 are admitted.
Thank you, Your Honor. May we publish those to the court?
Thank you.
And then skipping a bit forward in time, were you working on July 7th, 2026?
Yes,
And on that date, did you have another interview with Sherelle Knight?
yes, I did.
And at that interview, did you take photographs of follow-up photos of her injuries that day?
Yes.
And Your Honor, if I could have one moment to renumber.
Right.
And do you recognize those? And what are those?
She wasn't here when she came in for the interview.
And are those photos all fair and accurate representations of the photos you took of her follow-up injuries on that July 7th date? And the people would move to admit people's proposed exhibits, I believe it's 12 through 23.
Any objection or water?
No.
Exhibits 12 through 23 are.
And maybe publish those to the court, Your Honor.
Sure.
And if I could have one moment, Your Honor. For the students.
Cross-examination.
Good afternoon, Detective. My name is Ben Denowith. I'm the public defender. So you took pictures of 2 knives, is that correct?
2 knives?
Yeah. Oh, did you take the pictures at the scene? Okay, but do you remember seeing more than 1 knife? Okay. Did you ever determine which knife was suspected to be in the assault?
One with the blood, like.
Okay, and that it's the one on the popcorn box in the picture, right?
That's correct.
Okay. Would you say the blade on that knife is about 5 or 6 inches? Or
The popcorn box, I think if the detective drew, I mean, I could be speculating, but I mean, it looks like it's put by a popcorn box to show the size of it.
okay, can I retrieve those pictures from the court?
Which ones you know?
One moment, the popcorn box. Okay, so
It's exhibit 10.
thank you. I'm just gonna ask you about exhibit and. So
Can I see it?
okay, I'm sorry.
Thank you.
It's actually probably bigger than 6 inches, would you say? Was that the standard size popcorn box that, they give away for free at Ace Hardware or whatever? Okay,
Yes.
so. I don't know, is it about the size of like a notepad or a little shorter maybe? Okay, would you agree that's a fairly sizable knife that could definitely kill someone if used properly?
Anyway, I think those.
Okay, or improperly, I should. Okay. Did you send that knife to the lab for any work? And why was that?
Because I don't think there was any suspicion of the knife would have his DNA on it, so inside his house. And the knife had blood all over it, along with blood that's on her. We had no. So it seemed irrelevant to send it.
Did you have any other suspects? And you were aware that initially, 911 was told by both the defendant and the complaining witness that there were 2 suspects that were not the same race as the defendant. Is that right?
Yes.
Okay, but you had eliminated them by the time of your execution of the search warrant?
According to the officers, the victims. Statute.
Okay, and so there was no reason to look for any DNA or fingerprints from any other suspect because of those statements, correct? Nothing else for defense?
Any redirect?
No, you're.
May step down. Thank you.
Yeah.
We will have no further witnesses, Your Honor.
Any witnesses for the defense?
No, Your Honor.
Go ahead.
There are people who buy them. Or I would ask the court as part of item to add 2 additional counts. One of assault with intent to murder, which is MCL 750.83, and that is a life offense.
28.83.
750.83, Your Honor.
Say so. Okay.
And I would also ask the court to add a count of unlawful imprisonment, which is MCL 750.349B, which is a 15-year and or $20,000 fine. Count 6, I believe, and 7.
Yes. Okay.
Your Honor, I would ask the court to bind over the defendant as charged with the additional counts. The court heard from Sherelle Knight as to the assault committed by the defendant, in which he attacked her from behind, punching her, hitting her numerous times in the face area, along with a stab to her neck and a cut to her lip that were both extremely serious. She did testify that she felt that the defendant was intending to kill her at that point and that she was in fear for her life. The court further heard testimony that there was the assault with the knife and that just a domestic relationship. I do believe at this point we have that the burden of probable cause as to all charges, including the additional charges, and would ask the court to bind over the defendant as charged to circuit court.
Response.
Your Honor, the defense objects to the bind over. I'd first like to address the false imprisonment. The elements are that he knowingly restrained her. I didn't hear any testimony about that. She says,
What about the sitting on the legs and they're trying to get out? Wouldn't that constitute the requisite
I don't think
restraint?
he's preventing her from leaving. I thought that was part of the assault. I think the false imprisonment specifically requires not allowing another person to move. If you're assaulting a person, and this is obviously in an apartment, which is a confined area, but an assault in a confined area is not necessarily a false imprisonment unless that person is not allowed to leave. I think you can show the defendant did not intend that because the complaining witness said he called 911. He is the one attempting to get her help. And I mean, yes, I understand that is not necessarily consistent with the rest of the story. That's what she told us. She's assaulted. She doesn't know why. He calls 911 and starts putting a pillow on her injuries. So there's no intent to restrain her from going anywhere. And then the officer shows up and they all walk out apparently, and the officers notified.
But couldn't the false imprisonment occur and then the defendant do something else? That doesn't negate the false imprisonment. And specifically what I'm talking about is once he does the stabbing and then sits on her legs, that in and of itself, this court believes, I think, unless you want to tell me something different, can constitute the false imprisonment, because at that time she's restrained from leaving. If at some later point he gets up off her legs, may change his mind that he needs to call whoever, it doesn't really matter. That doesn't negate the false imprisonment, does it?
I don't think you can be false imprisoned for 10 seconds if somebody's sitting on your legs, though. I mean, he has a specific intent to restrain her. So it's not that he's sitting on her legs. These are all specific intent crimes. He has to intention.
That's going to be a question of issue for the fact finder, isn't it?
It's an element. No, it's an element of the crime. It's right here in front of the court. It's probable cause standard, but sure, they have to show all the elements.
Intent. This court can't decide intent.
At
this stage. No, I can't. If there's zero evidence of intent, that's one thing. If there's evidence of something that could constitute or go to somebody's intent, I certainly can't make that finding at this stage.
There's no evidence he intended to restrain her. There's evidence he tried to have her leave.
Counsel, go on with your article,
Okay,
because you're wrong.
literally calls 911 by the complaining witness's testimony, which is not falsely restraining her, it's getting her transported to a hospital. So, no, I don't think sitting on her legs. And, followed up immediately by he's tending to her medical needs, which she alleges he just caused, but she says he's, being nice to her and wiping the blood off her face. This is, it's not something you see every day, but that's not intending to restrain her. He's attempting to ensure that she's okay. So next, the assaults. There's now 4 different assaults in front of this court. Count 3 is DV, but with the third offense notice, that's just the misdemeanor that they were in a dating relationship and there was an assault. But counts 1, 2, the FA, and then the added AWIM 6. Defense objects based on his intent. She says that's not him. She looked in his eyes and doesn't know what he's doing. And the next, it seems like in the next few seconds, the next sequence is he's trying to stop the bleeding. So no, you can't say that he intended to kill that person with, a gigantic knife that was basically bigger than her neck. She gets a cut that takes, it looks like 5 or 6 stitches and is released from the hospital the next day. If you stab a person in the neck with a 10-inch knife and you intend them to die, I think it would happen. That is essentially, a surface wound. They don't release you from the hospital the next day if somebody's cut. I don't think these injuries at all show an intent to murder. I don't think it shows an intent to create bodily harm. What is the bodily harm? I understand she's scarred and that is horrible, but what is the great bodily harm? She's out of the hospital the next day. She's able to go to the police station. She does have injuries depicted in the photos, but what is the great bodily harm? She's, doesn't have a broken jaw where she can't eat for a month or something like that. It's clearly an injury and it's a horrible situation, but it's not great bodily harm to have a cut that requires 5 stitches. And I don't think his intent to do anything worse at all being inferred, because he clearly had the opportunity to do much worse. If you believe the complaining witness, he's somehow out of his mind for some period of time, but he clearly has the ability to kill her. He has a giant knife in his hand. She says there's knives everywhere. Okay. If he has the intent to kill, he would have killed. If he has the intent to do great bodily harm, he would have done great bodily harm. If he has the intent to disfigure her, I think she would have been disfigured. I don't believe there's any testimony that her injuries for the rest of her life, so I don't believe she was disfigured. Or she may have been, but there simply wasn't testimony to support it. Disfigured means you are made to look different forever. If she is not disfigured, there's no intent to maim. So I'd ask the court to quash counts 1, 2, 6, and 7. The defense has to concede the DVs. The misdemeanor is not up today. And the defense would ask the FA based on the testimony. Problem.
All right, we'll just add a few for the court. The court heard testimony from Miss Knight as to the defendant almost hitting her jugular, and that required 6 stitches. She also has stitches in her lip and scar. She had bruising on her face, on her legs, on her arms. What I saw was petechiae in her eyes in the photos from this assault from the defendant. She also has the moment of where the defendant has the knife and tells her, "Don't scream or I'll kill you," which also would fit the unlawful imprisonment as to restraining someone with a dangerous weapon. Furthermore, He then not only calls on one, but he makes up a story that she has to go along with until she's able to get out of his grasp, basically, with officers to finally explain to them what actually happened. So I do believe that we have met our burden by probable cause as to all the charges and would ask the court to bind over the defendant as charged to certain.
So that we can get one thing straight. Where there is evidence of someone's specific intent to commit a crime, this court is not the final arbiter of that intent. Because one intent may be shown by what they did, what they said, how they did it, or by any other facts and circumstances and evidence. Those are particular items that that would be necessary to go to the trier of fact to make a determination in this case. The testimony of the victim in this case indicates that the defendant in this case began doing something behind her. And I'm just going to say this: I find Miss Knight's testimony exceedingly credible because she could have exaggerated a number of things at certain points, but she very clearly would state when she could see something, when she couldn't see something, what she knew and what she didn't know. She didn't realize the disfigurement on her lip and face, or at least the extent of it, and she said so, but that she knew she had been sliced or cut because of the blood, as she put it, spilling or dripping from her face. The defendant then, at some point after doing all of that to her, and I want to make it also clear that the people are absolutely right. Her testimony was some of these slices, punctures, and pokes at her that she received the stitches in her neck very close to her jugular. Any event, and when one gets to the false imprisonment or the unlawful imprisonment, that can be shown by what somebody did physically. It can also be shown by what they said at the given moment, and a combination of all that certainly could form the intent necessary to constitute the unlawful imprisonment. Testimony of Miss Knight is that at some point he comes around, he sits on her legs, staring in her face, and then utters those words of "Don't scream, I'll kill you," or the like. That's certainly in this court's mind is enough to constitute the actions of the defendant, as well as his words, to constitute the requisite restraint necessary for the unlawful imprisonment. I am a bit confused by the defendant's argument that he could have done something, but because he didn't or wasn't successful, there couldn't have been his intent to commit murder. It's an interesting argument, because what that would mean is we would have no need for assault to intent to commit murder, because there would be nothing that would happen if somebody didn't actually complete the crime of committing them. The wounds that are exhibited, particularly in exhibits 1 through 6, or 1 through 5, of the defendant's head area and her body, and cuts that she obtained. I certainly believe that the people have sustained their burden, as certainly to count 1, the intent to maim. I don't know if one talks about the permanent disfigurement, but it really is the mutilation. Its permanency can be changed by, quite frankly, medical or surgical procedures, but that doesn't. It's the act of the maiming or disfiguring of the person that constitutes really that offense. As to count two, the assault with intent to do great bodily harm less than murder, or by strangulation, if you listen to the testimony of Ms. Knight, I think certainly the people have sustained their burden in showing that offense. With reference to count six, the assault with intent to murder. Guess we can all be thankful that the defendant just wasn't successful, but I think his intent at that given moment, that may have changed at some point, but his intent at the moment that he cuts her face and then slices her neck, certainly a fact finder could conclude that it was his intent at that moment to kill or murder Miss Knight. So for that, and the court encompassing all of the record, the court does believe that the people have indeed sustained their burden. We bind the defendant over to stand trial on counts 1, 2, 3, 4, 6, and 7 with count 5 following.
And with the formal reading.
If you're waiving presentation of the information at this time.
Yes.
Defendant standing mute, waiving formal reading, standing mute to those charges. Court will enter a not guilty plea as to all 7 counts. Pre-trial in this matter will be set
11th at 1:30 with Judge Cummings.
August 11th, 2026, 1:30. Bond. What is his bond? It one,
Surety.
quite frankly, given what I've seen, not high enough, but I'll leave it where it is. Bond will continue.
Thank you. And information on the report as soon as possible.
Very good. Oh, right. Who was that?
I can't answer one. You like
Absolutely.
That's
Yeah. I gotta wait for her. All right, tell him. Mr. Reed's in back.
Please turn me.
Who?
Rodney Clark.
He's not gonna be here.
Mr. Clark?
So you've been in communication with Janaza then?
Yeah, I'm.
Oh, okay.
I'm at the jail right now.
Okay, all right. Then I'll call him. Court does call the case of People versus Rodney Clark.
Bring the people. Assistant Public Defender Ben Dunaway for Mr. Clark, who is not present. Your Honor, unfortunately, Mr. Clark had told my colleague he was running late and on the way here. I think that was about 3 hours ago. If the court would adjourn this for a week, we'd appreciate it.
Actually, what she said is he was gonna be here at 3 because he was at some training, so I, in good faith, said it over, but yeah, I'm done. Benchmark, go ahead.
President Benchmark, just for the record, people doing this work here today, we were able to proceed, we excused them. Agreement, and appear or to effectuate.
Benchmark will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. Warrant will issue immediately. Then can I get Mr. Reed? Yes.
We're ready for read. Thank you.
You can play.
Yes. Thank you. Court does call the case, People State of Michigan versus Christian Reed.
Good afternoon, again, Your Honor, Raymond Joking People.
Good afternoon, Your Honor. Christina Saxon for Mr. Reed.
On this matter, I hadn't gotten to, there's a request to adjourn preliminary examination, and I may concede to that. However, there's a bond violation report. The record should reflect that the defendant has not contacted community corrections. It's been regarding his GPS and the like. He in court that he made calls to community corrections. There was some issue as to going through the phone and what that was going to show and reveal. But in any event, the court did call community corrections. He's instructed to call the agent, which goes through to the computer as well as to the phone. There is no indication of any calls and or messages from the defendant at all.
Your Honor, as stated at the bench when you were kind enough to give us a bench conference, the phone number to the agent was on paper and misplaced. However, he received the number to community corrections by text. But as stated earlier, his phone was broken. So when his GPS tether bellowed out a phone number, he did not have pen available. He and his mother, because his phone was broken, Googled Washtenaw County and in an attempt to get to community corrections. I looked at her phone bill, which shows each call. I do see where multiple calls were made to what turned out to be the public defender's office. Unfortunately, a message was left, but they did not return the call saying you have the wrong number. This is who you should call. Furthermore, Your Honor, I would ask, in the face of this potential violation, that because I was just appointed at 2:30 yesterday and just noted bond violation, that you would set this for show cause so that I could get the proper evidence to show that at least attempts were made, albeit to the wrong phone number. He has been compliant every other way. He does have a job. He works at Taco Bell. And again, to my knowledge, this is a matter of a phone call that should have been made, but he now has the number and to lock it in, tattoo, whatever he has to do to not misplace this number again, if the court's not inclined to give us a show cause hearing. As stated in MCR 3.606.
Given that you were just appointed, I will adjourn the preliminary examination to my next date, which is August 18th, 2026, 9 a.m. That is before me. As to the defendant's bond, he has not complied with his condition of bond. Certainly, you may raise by written motion, but I'm satisfied that the defendant had not called community corrections, had not kept in contact with community corrections, despite their attempts to try to contact him. I'm frankly having a hard time believing his story regarding the phone. Certainly could have been that there were calls made. There are no records of any calls made to community corrections, leaving a message to them. As I further had indicated previously, he could have at any given point in time, should it been a problem, he could have gone down to community corrections and straighten the issue out. None of that did the defendant do. So certainly you may raise and bring whatever evidence before the court that you can find, counsel, that may show or have the court draw a different conclusion on it. But at this point, what I'm going to do is the defendant's bond is hereby ordered revoked. Defendant's remanded.
Your Honor, I'm going to ask that you allow me to withdraw from this matter then, because as stated on previous case, I will be out of the country on the 18th. And so as to not delay his opportunity, and being that I was just appointed.
Certainly you could file a motion. You did indicate that to me, and I don't want to put it out any further than where I have to put it out to.
Right,
So I'm giving the quickest date possible. If you send in if you contact the MAC office, send in a written motion, I will order your withdrawal and new counsel.
Okay,
Does that make sense?
it does.
That way. All right. Okay.
Thank you.
You love me, bro. That's right. Because we screenshotted the thing and I screenshotted the wrong part of the number. That's why I didn't get.
Ma'am.
Had to Google it. I'm sorry, we didn't know we could come up here and talk to nobody. We didn't know about that because we had a court date and we came to court. And we didn't figure out that it was a problem. We didn't know it was
If
a
you
problem.
want to listen to me, want to just talk, because I don't have to listen.
I just asked her that so I can explain to you further because she's not explaining it.
Well, that's not true. Counsel has tried to explain it. She's explained it. I looked at it myself. Counsel, that when you're talking about counsel not explaining something to me, you are wrong. This attorney came before me and she's been advocating so that your son did not get locked up. And she has stated all of those things while we were on the phone, because I don't really want to lock your son up either. When we're on the phone talking to community corrections, she's on the phone talking to community corrections. She then came before the court at a bench conference so that she could explain and advocate for your son regarding his release. And then she did it. The problem is community corrections doesn't have a record of it. That's not her fault. So don't sit up there and try to blame her saying she's not doing her job or she's not explaining something to me. She absolutely is explaining something to me. And quite frankly, she's a very good attorney. And the problem is I resent you trying to blame her for what your son didn't do. Bottom line. I've also given her the opportunity prior to the withdrawal so that your son's case was not delayed. She's willing to step off of the case so he can have counsel and he can get before the court quicker. I've also offered her the opportunity to get to this court any information that may change this court's mind. So I'm done, because you know what? I'm done. I'm done. 14A stands adjourned.
What starts as a routine traffic docket quickly turns into a courtroom lesson in accountability. One by one, defendants step before the judge hoping for a break, but they quickly learn that excuses won't erase responsibility. The judge makes it clear, if you're willing to own your mistakes and work toward fixing them, the court will work with you. But ignoring the rules comes with consequences. Throughout the hearing, several defendants reach plea agreements to reduced driving-related offenses. The judge carefully explains their rights, confirms that each plea is voluntary, and then asks the same important question. What are you doing to get your license back? Instead of focusing only on punishment, the court repeatedly pushes defendants to get back on track by paying outstanding fines, setting up payment plans, and following through with legal requirements. For many defendants, jail is avoided, but not without conditions. Rather than imposing time behind bars, the judge orders 4 days on the court work program, reminding everyone that showing up, following the schedule, and taking responsibility is the price of earning a second chance. The message is simple. Accountability beats excuses every time. One of the most memorable moments comes when a defendant explains he's only weeks away from getting his driver's license back. Instead of letting the situation become another setback, the judge works with the prosecutor to amend the charge so it won't create additional licensing consequences. Then he gives the defendant a challenge,